This will sound obviously correct that a stranger out of a contract cannot suffer loss and cannot be a beneficiary to it too at the same time. So that is talking of privity of contract. So when we are talking about privity of contract, the rule says that unless expressly stated in the contract, a person who is not a party to the contract cannot enjoy the benefit of the contract and also cannot suffer the burden of that contract. So it's on a neutral ground. But just like everything in life, there's always rule, there's always exception to the rule. So we want to talk about privity of contracts, which I just mentioned, and the exception to the rule of privity in law of contracts. Don't forget, it is the law of contracts that we've been talking about. So one of the exception we'll be talking about, which we are going to spend a few time on, is restrictive covenant. What is restrictive covenant? We are going to look at negotiable instruments. We are going to look at exception of agency. We are going to look at trust. We are going to look at insurance as exception. So for new viewers, we said thank you. Please go and subscribe right away and click that bell. Click all so that anytime we upload, you will be the first to receive. And for the returning viewers, we say thank you. So without any further ado, let's go directly straight into the law of contracts, looking at the exception to the privity of contracts. So restrictive covenant. When we are talking about restrictive covenant, we are talking about covenants, especially as it relates to landlord, tenants, buyers of land and property. A restrictive covenant between the first buyer and the original landowner could be extended to subsequent user of the land, user of the property, and the like. Take, for example, a party A and a party B, both landlord and the first user. But let's say party B is the buyer of the first buyer of the land now and sold to party C. Party C does not know party A. That is, party A is the original landowner. Party B, the first buyer, had moved on and sold the property duly, legally to party C. If there are restrictive covenants on the usage of that land, let's say for any reason the original landowner said that the land or the property should not be used for one or two purposes. If party C should try and use it, whether knowingly or unknowingly, don't forget that in law, ignorance is not an excuse. The party C that bought the land and the current owner will not be able to carry on that usage, because even though legally he or she is the owner, but because there is a restrictive covenant from the onset, which he or she may be aware of or not aware of, the person is banned by that first contract. So that is restrictive covenant, and that is an exception to the rule. Let's move on to negotiable instruments. Negotiable instruments, especially when we are talking about, and here I'm going to sound a note of warning to us professional, especially those of us that do guarantors. It's good to guarantee other people, but we should know one thing, that once we are guarantors, we are bound equally and will not be exempted from that transaction. So it's another exception to the rule of privity of contracts. because a guarantor will be a substitution for the real party if they should break the law of contract. If anything should happen and the person that you guarantee or that I guarantee could not make good of that his or her own part of that agreement, the guarantor will be made to be substitution for the initial party. So that is unnegotiable instruments. Also, agency law is another contract. But when we are talking about agency as exception to the privity of contract, we are talking about an agent to the real owner or to the real party having a power of attorney, which means the person can act on behalf of the real party. That that agent now that has the power of attorney can sue and be sued even in the contract that was entered initially into by the real party. So that is agency. So we professionals, please, let's be careful of anybody we engage as our agent to do things, because directly or indirectly we are giving power to them. So I move on to trust. Trusteeship and trustee is another exception. When we are talking about the law of trust, we are talking about having a person empowered to stand in the gap for other or for other interests. So a trustee who holds property in trust for another can sue in respect of that property. A trustee that is empowered to hold a property on behalf of another can sue concerning that property and of course can be sued likewise. Let's move on to insurance. Let us move on to insurance. Insurance is another exception to the rule, and when we are talking about insurance, when it comes to the third party, especially third party liability, the third party has power to sue even though he or she was not part of the contract between the insurance organization and between the insured. But if anything should happen and let's say for example the insurance company will not make good their own side of the rule and engagement, the third party can sue and of course can be sued. Now these are the summary of, or this is the summary of privity to contract. Privity of contracts simply ensure and protect in the first place the interests of the parties to the engagement. Anybody that does not or was not part of the contract cannot gain or benefit from it. That should sound like a benefit and a protection, right? But at the same time, there are exceptions to it, and those exceptions are what we had mentioned and a quick recap from Gbenga James Olatunji FCA. For those that are just viewing us for the first time, that is my name from GJAMES Associates. Restrictive covenant, negotiable instrument, agency, trustee or trusteeship, insurance, especially when it comes to third party insured, negotiable instrument when it comes to guarantor, restrictive covenant when it comes to property, transference of property, trusteeship especially for people engaged in NGO and the like. From GJAMES Associate Channel, join us for next episode. We are value to life, we are value to your businesses.